I feel like I'm part of the Rebel Alliance and we're fighting against the Empire, which is state action. And don't think I'm trying to talk you into taking the plea because I'm avoiding trial work, because I like trial work. That's what I went to law school to do. My client was African American, and we live in a predominantly white community. They're not outwardly racist, but they may have these implicit biases built in.
I tell a lot of my white friends, I say, I can probably get away with saying this, but you guys can't. I guess this is the society we live in. But I say all that to say, we all have some implicit biases. That doesn't automatically make any of us racist.
It's a very uncomfortable conversation to have. You're having it open in the courtroom. Yeah, it's very taboo. One of the questions he had was like, well, is it too late for me to take the plea? And I said, yes. This court, once they send the jury summons out, they don't let you do any more plea negotiations. So that ship has sailed. And they had anticipated that he was under the influence of drugs. They only screened him for alcohol.
Oops.
Yeah.
I don't know about you, Brad, but I rarely see the guy go in, make a statement, and the police says, you know what? We believe you. You can leave. That's never happened to me.
Yeah.
Hey everyone, welcome to the Iron Gavel. I'm Chris Washington, a criminal defense and personal injury attorney with over 17 years of courtroom experience. On this show, we bring gripping true stories of justice strategy and humanity from inside the courtroom. Today's guest is attorney Bradley Rook. Bradley's client was charged with DWI with drugs. I'll let Bradley explain that. The police claimed his client failed all 5 standard field sobriety tests. You have to hear how Bradley fought back, which ultimately led to his client being found not guilty of the charges. But before we unpack the courtroom drama, let's get to know the person behind the victory. So Bradley, tell us a little bit about yourself.
So I'm from upstate New York. I practice in a small county called Fulton County. We're in the capital region, so we're about an hour outside of Albany. I've been in the public defender's office for about 6 years now. I used to run the family court side of our office. So one of the unique things about the state of New York is we provide indigent defense in family court actions. So I know a lot of states don't do that. And I've been practicing criminal law primarily for the last 3 years.
Okay, cool deal. So what inspired you to be a criminal defense attorney?
Well, I think everybody goes to law school with the idea, or at least I went to law school with the idea to do good.
I say most of us go there because we actually want to do good.
So one of the things I think that gets misconstrued about criminal defense or public defense work in general is that, we're representing guilty parties, and that's not necessarily the truth. I really look at criminal defense and my job as a public defender as upholding the Constitution, because everybody has a constitutional right to counsel, or at least a defense attorney that's working on their behalf. They shouldn't be left to be eaten by the system.
So what would you say is one thing people misunderstand about what we do?
I really look at my job every day as coming in, I'll use a Star Wars analogy. I feel like I'm part of the Rebel Alliance and we're fighting against the Empire, which is state action. So when you're looking at criminal cases, you're always making sure that people's constitutional rights, against search and seizures, self-incrimination, Fifth Amendment stuff, that was never impacted through the state's action.
So what would you say sets you apart in the field of criminal defense in the area you're located in? Because I know there's a lot of attorneys who do criminal defense. Why should someone feel a sense of relief when Bradley is hired or appointed to represent them?
I'll give a more blanket answer. I think people should not look down on public defenders as much as they do. We handle a higher volume of caseload than most criminal defense attorneys. So we are seeing things, 5-6 times in a month that maybe another criminal defense attorney only comes across once or twice a year. So I think we're much more versed in the issues that are present on certain cases, and we are plugged in with, our state network of defenders associations. So we're constantly getting updates, and I think we're probably more knowledgeable than some criminal defense attorneys, at least in my area, who are generally general practitioners. So they're not just focusing on criminal defense or family law. They're also doing estate work, personal injury actions. And so their practice is similar to the bar exam, where they know an inch deep and a mile wide, whereas our practice is much more focused. So we know a mile wide on, the criminal issues or the family court issues that we are constantly coming across and litigating.
I appreciate you saying that. There's been several attorneys I've interviewed on here who do public defender work and get not guilty verdicts. And the vast majority of the people I know who do public defense work actually care. Many of them have the issue of really high caseload. A lot of these guys and women still find ways to get through the files and give everyone the attention they deserve. Next month, October, will be 18 years, and 3 months ago, I took a contract position as a public defender doing LWOP only cases. So all of my cases are life without parole cases. They are murders or rapes, first-degree rapes in Louisiana. That is my entire caseload, and honestly, one of the reasons I did it was because it'll give me a lot more trials because those cases have to go to trial, essentially. The other thing about that made me want to do it is I didn't want a 100 caseload case or 200, or I know guys with 250, but my caseload will probably be somewhere between 10 and 30 at all times, which is great. So I would say this to the public. If a public defender is appointed to you, just don't make assumptions. Like, we all make assumptions and we know that can lead us down the wrong path. So at least give the lady or man who's been appointed to you a chance to show you what they can do, show you they care, show they don't fit some stereotype that's been created. That's what I would say to the public. What you think?
No, I agree with you wholeheartedly on that. I think public defenders sort of get a bad reputation. I'm managing about 200 cases right now. I pride myself on the fact I always try to have client contact before a court appearance. But some of us, our work schedules and our caseloads don't allow for that. So you really only get that 5 minutes in court, face-to-face interaction with your attorney. And I think that generally leads people to believe that their attorney's not doing the work that they need to do on their behalf. But, with 18 years of experience, as well as I do, most of the work that we're doing is in the office. It's so much paperwork, and I tell my clients all the time, especially as we're doing plea negotiations, you can accept the plea that, and it may be in your best interest. And don't think I'm trying to talk you into taking the plea because I'm avoiding trial work, because I like trial work. That's what I went to law school to do. Otherwise, I'm just pushing paper.
That's right. I wouldn't do this if I couldn't have trials. It would not be exciting. So let's talk about the case we're here to talk about today. If you had to give us a summary of that case, what would it be?
So my client is charged with DWI drugs in New York, which means that he was charged with driving while his abilities were impaired due to a controlled substance. In this case, they were alleging that he was high under the use of marijuana. Unfortunately, this is one of those rare instances where I didn't have much client contact outside of the courtroom. So one of the kind of particular things that you do come across as a public defender is your clients don't always have secure or consistent means of communication. So he was very hard to get in touch with on the phone. So I had probably only spent 5 or 10 minutes with him when we moved it to the trial calendar. And I sort of knew all the issues at that point, and the offer for him was a reduction. So we have a violation in New York. It's called driving while abilities impaired, and it's got lesser penalties and a lesser suspension time for your license. But in this particular instance, he was well served by going to trial because there was so many factual issues that were problematic for the prosecution.
Why would you say this case is important for the public to know about it?
I think 2 takeaways from this case for the general public. You have a Fifth Amendment right to remain silent. And most people think that the police are there to help them. So they constantly go in when the police call and give statements, or even when you're pulled over, you're making a lot of extraneous statements that you don't need to make. So my client had made some admissions during the roadside stop that he had used marijuana earlier in the day. And that was sort of like our big issue as we went to trial. That was one of the 2 issues I was most concerned about.
What's the other issue?
I don't know what it's like in Louisiana. So we're lucky in my jurisdiction. I think all of our law enforcement agencies now have body-worn camera. So one of the issues that I thought was problematic, as the officer comes up to the driver's side of the car, there's two passengers in the car. The passenger in the front seat is smoking a very large joint. And so I was hoping that this video wasn't coming in and we could suppress it. I didn't win at the suppression hearing. I guess in some instances I'm lucky again. A lot of the prosecutors in the DA's office here don't have a ton of experience. I think it would have been helpful for the prosecution to show the entirety of that video. At trial, they chose not to, but I was really nervous that if the jury saw this passenger smoking and the officer who's doing the stop is like coughing, and that's why he originally asked my client to step out of the car, I thought that that would be a very damning piece of evidence.
Wow. Yeah. That goes in line with what we said earlier, like you being a public defender, having so many files, having so many opportunities to have trials, you see things that prosecutors who get to pick and choose which cases they're going to take to trial don't necessarily get to see. Sweet. Let's talk about the penalties, the consequences your client would have been facing had he been found guilty as charged.
So if he was convicted of the DWI drug, sorry, I just have to look at my file because I want to make sure I have all the right information. So one of the things I do when I get discovery is I send my clients a cover letter, which goes over the charges and then any possible, sentence, worst case scenario. So if he was convicted of the DWI drugs charge, he did face a maximum penalty of 1 year in jail or 3 years of probation, or in New York, we can do some type of split sentence. That's also together with any court-imposed fines, which the fine is a maximum of $1,000. We have a mandatory state surcharge of $395. And then there's also DMV implications. So DMV will hit you administratively with some more fines. He was looking at a 6-month license revocation. He'd have to enroll in a drug and alcohol program, and he'd have to attend a couple other programs relative to like drinking and driving. So we make them attend a victim impact panel, and he'd have to enroll in an impaired driver program, which is about a 7-week course here in New York.
So he would have had to do a lot of things that would have been uncomfortable.
Yeah, I mean, on these DWI or these alcohol-related traffic infractions, they really throw the book at you. You're looking at a couple grand in fines, and then you have all of these time commitments. So if you're working, these time commitments can really eat in or affect your ability to continue to work, and you have all these fines to pay on top of it. So you really need to be able to work to afford those.
So what was his emotional state when he first came to you?
I mean, our 2 court appearances before we put it on the trial calendar, he was kind of agitated, which you deal with that a lot with clients. They don't want to be there. They think that they're charged and they shouldn't have been. So when we had moved it to the trial calendar, that conference that we had, he was just very adamant that he wasn't taking a plea, that they shouldn't have charged him. And I try to frame all of my conversations about plea and trial as like a risk. So, my most recent LinkedIn post, I think lawyers are like doctors. We are constantly weighing risks and benefits. And I find framing that for clients really helps them understand, because I'm not gatekeeping. If you want to go to trial by all means. But just understand these are the risks that you have if you're convicted, and you're going to mitigate those risks if you take this plea and you sort of know what you're getting. Doing jury trials, as well as I do, it's sort of always a jump ball. You could think you have the greatest case in the world, but the jury could latch on to one little thing and it's over. You get the conviction.
So let's get to the trial. I know you touched on this earlier because you talked about your issues, but right before the trial, what evidence does the prosecution have that you found concerning?
Again, my client had made the admission to the officer on the body, and it's on body cam, that he had smoked earlier that day. Again, that passenger who's smoking a large joint of marijuana during the traffic stop. And then, of course, the officer's reaction that he's coughing, and he's like, I don't smoke marijuana. This is too overpowering. Can you please step out of the car? I thought, oh, geez, the jury's really, especially the front seat passenger, I thought a jury would really latch onto that. Because as the officer comes up, all the windows of the car are rolled up. So, there's that, I guess, popular belief of that you can have contact highs. I've never looked into the science on that, so I don't know how true it is. I had real concerns about that. The other concern I had, my client was African American, and we live in a predominantly white community. So that was something that I sort of had baked in to my trial strategy. When we had done our suppression hearing, the officer that conducted the roadside stop, that was in my list of questions for him, did you treat him different because he's black?
So let's talk about your strategy. What was your strategy? For those who don't know, in a criminal case, we get what's called discovery, where the prosecution turns over all the evidence. So once you got all the evidence, what you just talked about that concerned you, in addition to whatever else you received in discovery, what was your strategy for taking apart the prosecution's case?
So as I start to build my trial strategy, the first thing I do, we have like uniform sample jury instructions. As I start my trial strategy, I always pull the sample uniform jury instructions. That way I know exactly what elements the prosecution needs to hit and what the jury's going to hear. That way I sort of know where the case is strong for us and what to hammer on. So with my client, I really narrowed in and focused on impairment. So the case law in New York defines impairment as any impairment that would affect a reasonable driver. So impairment is that the driver is incapable of employing the physical and mental abilities which he or she expected to possess in order to operate a vehicle as a reasonable and prudent driver. And so my client is pulled over just a couple blocks from his house. So he hasn't been driving long. The stop, I don't know if it's pretextual. So my client did have some criminal history, so I'm sure law enforcement knew him. But they originally stopped him because his taillight was out. They sort of have probable cause to start the further investigation from that. So, but there was no accident. He didn't run any stop signs. He's not swerving all over the road. So there really was a question as to if his abilities to drive are impaired, despite all of the other facts and circumstances.
That brings us to, it's trial time. Now that you have your theory, now that you know what the evidence is, let's talk about jury selection. Your preparation for jury selection, what points you hope to make during jury selection, and how that process played out.
If I remember correctly, I sort of broke my voir dire questions for jury selection down into like 4 categories. So impairment was really important, and the jury's background or feelings on marijuana in general. We always hit, I think as defense counsel in general, we sort of hammer that our client's innocent. You have to prove him guilty. So that was definitely built in as burden of proof stuff. Then we get into police credibility. You're not going to weigh a police officer's testimony more than, my clients or anybody else who may testify. And of course, I built in race into my voir dire questions, just reminding people of implicit bias. A lot of people, they're not outwardly racist, but they may have these implicit biases built in based on cultural norms or, their life experiences.
I tell people, and I'll say this, I tell a lot of my white friends, I say, I can probably get away with saying this, but you guys can't. Like, growing up, I was told things that I had to reject at some point about white people. And I know a lot of white people who were told things about black people that they had to reject. But I kind of get to say, I guess this is the society we live in, I kind of get to say, like, I was taught some things that I thought was racist and I rejected. And my white friends don't always get to say that. But I say all that to say we all have some implicit biases that are ingrained from the moment we come out of the womb. But that doesn't automatically make any of us racist. It's what do we do when we recognize that bias is coming into play? Do I accept it and run with it, or do I reject it? I reject mine. So my friends are people who I like, and the people who I talk to are the people who I like, and it has nothing to do with anything else. So I think a lot of times in jury selection, you can actually get prospective jurors to recognize that they have implicit biases, that they're a subconscious. What are you going to do consciously when that subconscious bias comes to the surface? And if we can all deal with that in a fair way, then we can deal with a lot of the racial issues we have here.
Yeah, no, I agree. Just to talk about race a little bit, as a white person, it can be sort of uncomfortable to ask these type of questions, especially to a jury. Even though most of my potential jurors were white, it's a very uncomfortable conversation to have. You're having it open in the courtroom. Yeah, it's very taboo. I will say most of my jurors had heard of implicit bias, or at least they said they had. They were open to this idea at minimum that they could be bringing these biases in. And I think being open to that idea helped rebut any notion that they may have had.
So they actually talk to you on the subject matter.
Voir dire questions are very open-ended because you want the jury to talk. You're really trying to get their perspective on the world because you want to make sure you're picking good jurors that are going to be fair and impartial in this case.
I want to go through the things you covered in jury selection. I wrote it down: impairment, marijuana use, police testimony, and race. So we talked about race a little bit, but I got one more thing I want to touch on, and then I want to jump. What were some of the questions you asked the jurors with respect to race, and what were some of the responses you got?
So I asked open-ended questions like, what does implicit bias mean to you? Has anybody had bias training? Do you believe a person's race or background can affect how they're treated by law enforcement? And do you recognize there's some cultural differences necessarily between races? So the presentation may be different. And I really needed to plant that seed in particular, because one of the things they're saying is my client has slurred speech. My client had a very distinctive way of speaking. When I watched the video and I had interacted with my client, I sort of knew it was just the way he presents. It's not him being impaired. He just sort of talks kind of slurred, muffled. And that may not be a race thing. Rural upstate New York, so we got plenty of rednecks up here who also sort of slur and don't enunciate. So yeah, those were my questions going in. I don't think I'm looking at my juror notes from selection, and I'm not seeing that I wrote anything in particular about their responses.
What I tell people, jury selection is the one part of trial that's difficult to do alone, because if you're the person up there talking to the jurors, you're not taking notes, or you shouldn't be taking notes.
It really hones your multitasking abilities. But yeah, I just generally recall everybody being like, oh yeah, I've heard of implicit bias. And I had a couple people, we had a social worker in the jury pool. We had a lot of veterans in there, a couple of nurses and people in the medical field. So they all seemed to have heard of it or had gone through some type of bias training. So going into selection, I felt like we were on pretty good footing.
Let's talk about the marijuana use. Since marijuana is becoming decriminalized and legalized in a lot of states, what were some of the thoughts people had with respect to general marijuana use?
Our community here is relatively older and it's pretty conservative. So I was anticipating people having a lot of preconceived notions about marijuana use and having a lot of negative connotations with it. And as I went through jury selection, it didn't really seem to be playing out that way. People seemed to have working understanding of the impacts of marijuana usage on your abilities. So that wasn't as big of a hurdle as I anticipated.
How about police testimony?
For our trial, the state only presented testimony of 2 police officers. They put some of the body cam footage in, but there was no physical evidence, and my client ultimately chose not to testify. The officer that conducted the stop really offered the most testimony. The second officer that testified was the certified breathalyzer administrator, so his testimony was pretty narrow and limited, and that was one of the state's big screw-ups with my case, is they had only tested him for alcohol. They never took a blood sample to test him for drugs, even though he was arrested under DWI drugs and they had anticipated that he was under the influence of drugs. They only screened him for alcohol.
Oops.
Yeah.
Knowing that the officers were the star witnesses for the state, you had to deal with them in jury selection. So how did you deal with the fact that they were going to hear from police officers? And one of the issues I'm assuming you have, which a lot of us have, is that police testimony will be given more credibility or weight or belief than a person who's a general member of the public. So how did you deal with police testimony and voir dire or jury selection?
Well, it was those standard questions. You're not going to weigh a police officer's testimony more than anybody else's. You do understand that the police are not always correct. Our jury pool, there was several members who either had law enforcement background or had family members that were in law enforcement. So it was sort of fleshing that out too, that they wouldn't come in with any bias. I think we struck 1, maybe 2 people for cause because of their relationship to law enforcement. I think the general public is sort of attuned now that just because, a member of law enforcement testifies to something doesn't mean that it's entirely true. Like, every witness just has their perspective on the events.
So let's go to what comes after jury selection, opening statement. I want to hear the prosecution, the highlights, the key moments of the prosecution's opening statement and your opening statement, in addition to how you dealt with whatever the prosecution said in its opening statement.
So the prosecution statement was pretty straightforward. They're trying to hit all their jurisdictional stuff. I always laugh when I do trials with our local prosecutors because they always say, like, the city, the county of Fulton, the state of New York, and they say it like 3 to 5 times in their openings and their closings. And I know they need to set the groundwork for that, but they say it so many times, and then they're so robotic about it. They like turn into the car sales pitch at the end of the car commercials where they're just trying to read it as quick as they can. And so that always makes me chuckle. But their opening statement was pretty much like, he had a broken taillight, they stopped him, then he presents like he's under the influence, so they run these SFSTs and he's impaired. So pretty straightforward, pretty consolidated. And I had anticipated this, so my opening statement was all about impairment and marijuana use. So just because you used marijuana, the effects aren't like alcohol, they dissipate over time. And was he impaired? That's your big question in front of the jury. He's not pulled over because he's committed any traffic infractions. He's not running stop signs, he's not swerving, there's no car accident. So I planted that seed in my opening, and then I hit it again in my closing.
After that, opening statements go as you would like them to go, I assume. And the prosecution gets to put on its case or start calling witnesses. Who do they call first?
So the first witness for the prosecution was the officer that conducted the stop. And, they pretty much just walked him through the whole stop, So you're on patrol. What do you observe? You make this stop because of this taillight. What do you observe when you walk up to the vehicle? And then they start to get into the standardized field sobriety tests. And so in this case, they did the horizontal gaze nystagmus, which they say he fails. They had him do the walk and turn, which they say he fails. I'm trying to remember all of them. The walk and turn turned very comical on my cross, though, because the body cam footage that they put in and they showed was just of these standardized field sobriety tests. So they were trying to show to the jury through these SFSTs that the defendant was impaired and he's guilty. But the video actually, I think, hurt them because as we're watching it, I was noticing a couple of things that I didn't necessarily catch early on. So particularly during the walk and turn, my client keeps turning to the corporal, who is the supervisor who happened to show up on scene, and he's asking the corporal questions. And then at one point, the corporal tells him, like, just keep going. So that was one of the things that I really got to hit this officer on with cross. Like, is it normal for you to have more than one officer administering these field sobriety tests? And was my client supposed to be listening to your instructions, or was he supposed to be listening to this other officer's instructions?
What did he say?
Well, he admitted that it's not typical for them to have more than one officer administering it, but he clearly gave him the instructions, and those were what he should have followed. And if I recall correctly, I do believe, so during deliberations, the jury had sent 2 notes. One of the notes is they wanted to review the video footage. And I think because of my cross, they really wanted to see how much this secondary officer was involved in the administration of the field sobriety tests. And I think that really undermined the state's case against my client.
That takes experience to catch that and recognize. A lot of times in these cases we're going in and the defense doesn't come to us until very late, and sometimes it has to change in the middle of trial. And the only way you become comfortable accepting changing your theory on the fly in the middle of trial is by doing a lot of trials. It comes from experience. It's just like playing a sport. If you go to practice every day and you never play in a game, you don't really improve.
Yeah.
That's great that you were able to hone in on this second officer who it appears he had minimal involvement.
It was like a 3-second exchange, and the other officers off camera, you can just barely hear what he says. You really have to be attuned and listening for it to catch it.
Yeah, I think that's what the jury wants to see the video for again, too.
Yeah.
Based on what you've told us. You take that witness, that theory about all these failed sobriety tests, you take that down because you just really hone in on a key detail that allows you to challenge the officer's credibility and challenge
Mhm.
all of the testing in general because they violated their own protocol. So after that
Right.
officer, who's next?
Well, let me circle back just a little bit. So with the first officer too, there was two other things that I really honed in on. So he was not what's called a drug recognition expert. So in New York, we certify officers with this enhanced training so that they have the ability to spot and understand the impairment from drugs. So as they went through his credentials, he's talking about how he has this advanced alcohol and impairment training. So I really wanted to hit him on like, well, there's this other certification and you don't have it, right? So, I got that out. And then I sort of rebutted a couple of the indicators that they said existed to do the SFSTs. So they said my client had glassy eyes. My client always has glassy eyes. So, I can't say to the jury, like, look at my client. He's got glassy eyes. But he had said he was really tired. He had driven back from New York City that morning, which is like a 3 to 4 hour drive for us. He had also said he had only drank coffee all day. So, they said he had cotton mouth and that was indicative of drug use, which I said, well, it was just dehydration because coffee, caffeine, diuretic. So, and then again with the slurred speech, like my client just has a very specific dialect. He doesn't enunciate well. And I think sort of gotten into that a little bit. And I had framed that like, could it just be part of his normal vocal tune and dialect? And I think the officer didn't really know how to answer that. He sort of like tried to skirt around it. I don't remember his answer exactly. Those three things really are, I think, what sealed the case for us.
And then they call somebody else afterwards.
I asked him like 3 questions. So this officer was called because he administered the breathalyzer, which came back 00. So I think my first question to him was, you also do not have this drug recognition expert certification. My follow-up was, and your only participation in this case was the administration of the alcohol breath sample. And he, of course, said yes. And I said, and that was negative? And he, of course, said yes. And then I was done. That was my whole cross for the second officer. He had no value, in my opinion.
Right. You got everything you needed from him. And you actually got everything you needed from the first officer, too. You tore through it. So, now the prosecution rests, right? And it's your turn to call witnesses. Do you call any witnesses?
So, the only real witness was my client. And you always talk early on to your client. You don't have to testify. It's entirely your decision. And I'll give you a recommendation as the time comes. So our trial was 2 days. It was 2 days because jury deliberation was the second day. So the prosecution rests, and then we take a brief recess. I talk to my client. I tell him, they already saw you on body cam. I don't think there's any value in your testimony. I think we have more than enough for me to do my closing, and I think you're better served not testifying. And he agreed. And I think when we had talked about it early on, he had sort of thought that he may not have to testify. And putting your client on the stand is very risky. And I think defense counsel understands that. And so you always talk about that. I did talk about that in voir dire. Like, my client doesn't have to testify. You're not going to take a negative inference if he chooses not to. And that's sort of what you're balancing with telling your client not to testify. Is there anything of value that is so pertinent that we need to get out from your testimony to take the risk that the prosecution can really beat you up, or the jury just decides they don't like you, or you're not truthful?
In most cases, our clients don't testify. We don't want them to. They shouldn't. And there are some times when I sincerely believe, like in a self-defense case, the client still doesn't have to testify, but it's my belief that if you're claiming self-defense, the jury wants to hear from you. Like, I won't say they have to hear from you, because I'm sure there's many lawyers who try self-defense cases and get not guilty verdicts, and the clients don't testify, but I believe the jurors want to hear from you in those.
Well, I mean, you and I both know self-defense is an affirmative defense. So I really think it's important, if you're raising that as the defense, that the client testifies, because I think the jury needs to hear from them in their own words to understand what their thought process was, what actually happened from their perspective. And I think it could be a make or break on a self-defense case.
So you call no witnesses, right?
No witnesses.
Is that customary in criminal defense? Or was this a rare occurrence that you had no witnesses?
I often don't have any witnesses. A lot of criminal defense cases I find are like he said, she said. And so again, this is like the nice thing about body cam. The jury gets to see your client and hear from your client through the body cam. So they get in the moment feedback of your client. So putting them on the stand doesn't necessarily help them because it's just going to reiterate what the jury already saw in the body cam footage.
And a lot of times I'll counsel clients, I'll say, I don't think this is a case where you need to testify because you gave a statement to the police. The prosecution's going to play it. So the jury has already heard from you. And that'll help some people, because some people want to testify and it's the worst possible thing that could happen. And they are persistent and insist. So if you have a video statement of your client to law enforcement, I tell my clients that you've already given a statement. The jury's already heard from you. So let's go to closing argument. Here in Louisiana, the prosecution goes first in closing, then the defendant closes, and then the prosecution gets a rebuttal closing.
If I recall correctly, for opening statements, the prosecution goes first, then the defense. But then for closings, the defense goes first, and then the people.
Now we're at closing argument. Take me through the prosecution's closing argument.
So the people's closing was really a rehash of their opening. But instead of previewing the case, at this point they get to say the defendant in city of Gloversville, Fulton County, state of New York, which they of course repeat 8 times, with their quick bitter speaker, is guilty of this offense. And on this date, he was driving from his home and you heard him testify that he had smoked marijuana or you heard on the video footage that he had smoked marijuana earlier in the day. And this officer pulled him over and he conducted these and he failed all of these. And then you heard from the other officer, which corroborated the original officer. And for these reasons, you have to vote to convict. I like our prosecutor's office. They're pretty easy to deal with, but I find some of their trial work a little uninspiring. And I'm sorry if any of them decide to watch this.
The opening, closing arguments they give sound mechanical.
And I prepped a lot of my closing ahead of time because you sort of know what testimony you're going to come across. But I think, you got to be a little fluid and flexible. I have notes on my closing of things that I knew needed to be added in or things that I wanted to hone in on, either pause for emphasis, whatever. So you really have to be able to work on the fly. And I think that comes with just the experience of doing trials.
I agree. So take us through your closing argument.
I said there was 2 questions, and essentially the prosecution had to prove not only that my client was impaired, but he had to be impaired by the use of drugs. I again hit on the burden of proof is beyond a reasonable doubt. So it's just not a mere inference that he was guilty or a probability. It needed to be almost insurmountable. And again, like I had indicated earlier, the impairment thing I thought was our strongest element going into this. So there's no accident. There's no VTL violations. And then when you're watching him on camera, he's not confused. He's not disoriented. He's cooperative. He's calm. He's not slow. And then he has none of these indicators that he's impaired. It's almost like the cops picked on him.
Based on what we know the verdict was, a part of the jury must have believed that as well. Have you gone through your entire closing, or is there more points to highlight?
No, I went through the whole thing. I did talk about each officer's testimony, reiterated that my client had driven from New York City. He said he was tired. So I was trying to rebut some of those slurred speech, glassy eye inferences so the jury wouldn't read too much into that. And I felt pretty confident. I hit on the SFSTs again, but I felt pretty confident that just from what the jury had observed through the testimony, they weren't going to put much weight on that.
No, I think you did great with the glassy eye. You got to talk about how he was driving, drinking coffee, which also dealt with the allegations of cottonmouth because coffee causes dehydration. And then
right.
you dealt beautifully with slurred speech. We're a country of one, but we are a country of many, many dialects.
Yeah.
There's many, many versions of English that people don't recognize. I grew up in a little country town with 2,000 people, and I can assure you that if you came to Simmsport, Louisiana with me, we'd have a few conversations. You turn around and you say, "Chris, what did he just say? What does it mean?" And it's all English, right? It's all English.
Right.
So it's great that you were able to point that out. So now I want to go to the most anxiety causing, the least favorite part of a jury trial for most lawyers, and that is deliberations.
Yes.
Right? Because at that point, it is completely out of your hands. There's nothing else you can do. All we do at that point is wait, hope, pray if you pray, and it's in the jury's hand. So I want to know, as you guys are waiting on the jury verdict, what's your client's emotional state and what's going through his mind if he shared any of that with you?
So we were sort of unfortunate. We ended our case late in the afternoon on the first day. So the jury had about 45 minutes to deliberate before the court closes for operating hours. They deliberated for about 15 minutes and then they sent a note out. And the note was that they wanted to review the footage. So the judge decided we were just going to be done for the day and we would start the next day with that review. So when we came back the morning of the second day, I always meet with my clients before we go into the courtroom. We take one of the conference room and conference for a little bit. So, I was able to talk to him a little bit. How are you feeling? You feeling confident? As much as it's nerve wracking for the defense counsel, it's much more nerve wracking for the defendant. So even though he felt confident that we were going to get a not guilty version, he sort of knew at that point it's out of our hands. So he's nervous. Even when he showed up the first day, one of the questions he had was like, well, is it too late for me to take the plea? And I said, yes. This court, once they send the jury summons out, they don't let you do any more plea negotiations. So that ship has sailed. So on the second day, obviously nerve-wracking, said he didn't sleep well the night before, understandable. And so we go in, the jury retires. We sent a note back to the jury, or they were given verbal instructions that we needed more specificity on their note for what they actually wanted to watch, because we weren't sure if they wanted to watch the whole video in its entirety. The way they had phrased it, it was a little confusing. So they retired for 5-10 minutes. They sent the second note. We brought them all back in. Because of the suppression hearing, they had to break the video up into like 3 segments. So we only had to watch one of the video segments. And it turns out after the fact, they were trying to figure out if the taillight was out, because that was one of the charges that they were given. So, they watch the video, they retire again. And I think they only deliberated for another 20 to 30 minutes. It was pretty quick deliberations. And then, of course, the most nerve-wracking part is, once they send the note out that we have the verdict, and then you're like waiting the 5 minutes for them to get in the courtroom and to get to the actual verdict. And you're sort of like, well, how'd it go? So you're trying to read the jury as they walk in, like, do they look happy? Are they looking at us?
Are they purposely not looking at us?
Yeah.
The verdict, the jury comes out, they have a verdict. What's your client's reaction when the verdict is read? And what is the verdict that's rendered?
So they acquit him on the DWI drugs and they convicted him on the taillight. I knew from watching the body cam footage that the taillight was out, and it was something, in hindsight, I probably should have hit on a little bit more to give him a full defense. But oftentimes as defense counsel, you either let the underlying go or you focus on the underlying to try to get the jury to just convict on a lesser offense than the top charge. They convicted him on the taillight. It was like a $50 fine.
Nothing. No jail time.
Yeah. Nope.
Not all these special conditions he would have had to complete.
And I think he paid it at the window that day. So
I bet.
He was,
he was ready to be done with that place, right?
Yeah. He didn't have like an overreaction when they acquitted him. You're kind of standing there waiting for the jury. And then, I think he took a sigh of relief and you could see kind of his shoulders relax from being so tense from before. But yeah, it's always a good feeling when you win.
See, there are people out there who would say, oh, this is a small case, a small win. But I disagree. I got to say this is a big case and a big win. And this is what I say. Your client was only facing 1 year in jail, right? That's how a lot of people would look at it. But only 1 year in jail, imagine what that does to your employment. You lose it. If you have a house and you have a mortgage, you lose your house. If you have a car, you lose your car. Every credit card bill you have, everything is affected. Like if a person spends anything more, in my opinion, than 6 months in jail, they almost have a reset to their entire life because the effects are detrimental, and it takes a long time, years, if ever, to recover from that. So small cases are big wins for the client, and people have to recognize that, or should recognize that. I can't tell people what they have to do, but I believe
Yeah.
it's something we all need to acknowledge, that when somebody's life and liberty is at stake, it's not just the guys who are looking at life without parole or 10, 15,
Hmm.
20 years. Most of us, if we had to go to jail for a year or more, our lives would be completely destroyed, and we'd have to essentially start over.
No, I agree. And every case is sort of a big case because it's your client's case. So, in their perspective, it is life altering. So, even though he had the risk of all these maximum penalties, if he was convicted, I don't think the court would actually have sentenced him to any of that. Maybe he would have gotten 1 year probation. But, in New York, especially on these VTLs, at least in my jurisdiction, they tend to not throw the book at anybody.
There wouldn't be anybody left. It'd be a ghost town.
Right. Yeah. A good chunk of my caseload is just people driving without a license. These aggravated unlicensed operations. So it's all about trying to get them to clear up their license, and then, you can drive freely again.
Which usually they don't have a license because they didn't have money, and now they have all these fines and other things they have to pay for. So they still have to live. They still have to eat. Pay the important things. The fine is not necessarily important or on their priority list. So in those kind of cases, I'm like, we're really penalizing people for being poor. Like, that's what we're doing here.
Yes. Well, and I tell a lot of my clients, these VTL violations, it's really a revenue generator for the state more than anything else. It's not about public safety if you think about it. It's about driving revenue for the state.
I agree, 100%. So what would you say, because I believe we learn something from every case. Sometimes we learn what we should do in the future. Sometimes we learn what we should never do. And sometimes we just walk away with life lessons. So what did you take away from this case and this trial?
I think every case helps you hone your trial skills a little bit. You could have practiced for 30 years, but every time you do a trial, there's something unexpected that happens. So it sort of just helps you either be more flexible and be able to go with whatever pops up, or you learn a valuable life lesson. For me, I wish I had reviewed the body cam footage a little more closer. Even though I'd watched it like 8 times before the trial, I really didn't catch that second officer's statement until I was watching the footage at trial. And that was something that I think was very strong for us. And if I had missed it, you never know what could have changed the outcome.
What would you say the public should take away from this case?
Again, you have a Fifth Amendment right to remain silent. And you are often better served by not saying anything at all.
I had a trial where my client, he made a statement. Truly wish he wouldn't have. Now, the statement was essentially, I did what I had to do. That's what the police said in their report. Now, the actual statement itself was a little different. In the statement, my client essentially said, like, the guy had a gun, I had no choice but to shoot. However, my client was from New Orleans. Post-Katrina, there was a lot of crime throughout the state where people from New Orleans relocated. So a lot of the young men from New Orleans, they would get lumped together, and some of them would be treated unfairly because they were from New Orleans, and New Orleans had a reputation for being violent. Essentially, if there was a shooting or any kind of physical dispute between people from New Orleans and people from whatever town or city the people from New Orleans were relocated to, the guys from New Orleans would, a lot of times the prosecution would assume they were the bad guys, or the police would assume they were the bad guys. And in this case, my guy was not that. He was a working man. He was a college graduate. Now, the guy he actually ended up shooting was a guy who was in and out of trouble all the time. But my guy was from New Orleans, and he was the one that was prosecuted. But I wish he wouldn't have given a statement, just because the jury got to see New Orleans, and I think that affected him. He wasn't found guilty as charged, but he was found guilty of a responsive verdict, and I don't recall what it was because it was so long ago. It was early in my career. I tell all my clients, I say, look, the best thing you can do is not make a statement. Even if you're completely innocent. I don't know about you, Brad, but I rarely see the guy go in, make a statement, and the police says, you know what? we believe you. You can leave. That's never happened to me.
Yeah.
I don't know of anybody who that's happened to. I tell people, look, even if it's at your house and it's on camera, tell them to take a look at the camera. The video shows you what happened. And there may be a point in time where we as lawyers will sit down and say, maybe I need to let the prosecution talk to him now, or if it goes to trial, this person will testify. But I don't want anybody who may need a lawyer in the future 5, 10 minutes, an hour after an incident to go in there unrepresented and make a statement. Invoke your right to a lawyer. Let a lawyer come advise you, and then you make your decision based on that as to whether or not
Right.
you're going to give a statement.
Well, because you can also help craft the statement. So, sometimes you're telling them to omit certain things that it's not necessarily making their statement untrue, but you're like giving more detail than you need to.
Right, great. So I appreciate you doing this. I think there's a lot I learned. There's a lot for the public to take away. Now, over there where you are, it's upstate New York, right?
Yes, we're like 3-4 hours from the city.
What city are you in?
Our office is in the city of Gloversville.
Do you get to do private work?
I have a small private practice. I focus on appellate work in my private practice, and I do some like qualified domestic relations orders, and I'm getting into a little bit of estate planning. Obviously, that's a balancing act when I have 200 clients caseload here, but I like to work, so I do it on my nights and weekends. That's why the appellate practice is really nice, because it's mostly paperwork and review.
So if someone was out there in upstate New York or anywhere in New York, because you can do appellate work throughout the state, right?
Yeah.
How would they find you?
I do have a website. It's bradleyrook.com. It's very uninspiring.
And social media. I found you on social media.
I'm much more active on LinkedIn now, so that's probably the easiest way to find me. I also have like an Instagram account. I don't know what my handle is for my business on there. I want to say it's like Upstate Divorce or something like that. I would do some uncontested divorces. My background is in family law, so I have like 11 years of experience in that. I am sort of restricted on the amount of criminal defense work I could do privately. But I'm always happy to consult with other lawyers too. I do get a lot of phone calls from the local bar about specific issues. That's one of the nice things about our local bars. We're very collegial. So we share information, and we're constantly talking about case stuff or changes in case law, statutory stuff. And there's a good group that we practice with up here.
I like that. We have a pretty decent criminal defense association here too that kind of shares information. But collaborating with lawyers, you learn so much. In fact, look, doing this podcast, I've talked to people all over the country. I learn a lot more than anybody's taken away from me, I tell people. So I enjoyed this, and keep winning. Let me know when you want to come back on to talk about another case. And
Sure.
And we'll do it. This was a pleasure, and I appreciate you taking out time on your Friday morning to do this.
Yeah, no, this was much more fun than I thought. I was a little nervous. I've never done a podcast or anything like this before.
People really need to know what we do. And here's a recurring theme. People don't know how to find a good lawyer, how to identify a good lawyer, who really is a good lawyer. And I think one of the ways we can show them is showing them lawyers who actually take cases to trial and who actually win. Because there's a lot of lawyers who don't even go to trial. And I say, How can you do criminal defense work and never have a trial? That essentially brings me to my number one goal of this podcast, is to help people find lawyers out there who will go the distance and who will, care about their interests until the very end. So thank you again for doing this, Brad.
Yeah, no, this was fun.
Take care, man.
Thanks.
All right, thank you. Bye. Thanks again for tuning in to the Iron Gavel. Don't forget to hit the like button, subscribe, and let your family and friends and anybody else out there know about the information that's being provided, and let them know about the Iron Gavel.